Just wanted to ask you this. It may not be very relevant but just to understand the legal framework. Why was it necessary to amend the RBI Act actually to bring in the scheme? I mean, as a matter of law, what was the reason?
Look,
We just have that. I have, in fact, it opened here at page 31 in your written submissions. Section 31 says that no person except the Reserve Bank of India or the central government can issue a bill of exchange, promissory note, or engagement for the payment of money payable to bearer on demand.
Well, it would be a bearer bond, my lord, because the reason seems to be, and that's RBI's report, that only central government and RBI is permitted under that section. The issuance is being done by SBI now. So
No. That's not the idea.
Yes, so it's somebody else which is being permitted, and that's one of the reasons which the RBI's letter also, which I think Mr. Bhushan showed to you.
Lord, there is nothing turns on the, and you will not succeed or lose on this. But, my lord, the purpose was
31.
Please see, my lord, 1. This was to make an exception to 1.
There's an authority or the legal
there
power.
There is a statutory backing to the scheme.
That's what to be confronted with the legal
challenge.
challenge.
That is a purely executive act.
Yes, otherwise it would have been challenged as an executive act.
Backing.
It could have been said that it's a bearer bond, only the RBI can issue, etc., etc. And therefore, my lord, with a view to empower the central government to come out with this policy.
And it would otherwise fall within the broad definition of a bill of exchange.
Exactly. Or a bearer, my lord, instrument. They say payment of money payable to bearer on demand to borrow.
Or engagement for the payment of money payable to bearer on demand. Engagement is very broad.
And one,
therefore that
Lord, subsection 1, first line.
Yes.
First line, subsection 1. No person in India other than the bank, that is RBI, or as expressly authorized by this act. So this is the authority given to the central government. That's all. But to give a statutory backing so that it doesn't remain an administrative instrument.
All right. Now what next, Mr. Solicitor?
Yes. In order to maintain confidentiality of the process, the data that is populated at both ends is recorded in a limited manner and not populated in the central databases. It doesn't contain the name of the donor. My lord, I can purchase it from Assam, Guwahati, because that is one of the SBI branches, and pay in Delhi, Indian National Congress or Bharatiya Janata Party, because their office is situated here. They can have their authorized account practically, generally in Delhi, but anywhere in the country. And I can purchase it from Delhi and pay to Trinamool Congress in Calcutta. They would have their account in Calcutta. So if I go and buy a bond worth 1 crore, the register would only say one bond issued, 1 crore rupees. My name will not come. The only person, my lord, I must, my lord, tell your lordships, which would temporarily come to know would be the cashier, my lord, when I go with my KYC documents. Because
the issuing bank.
Yes, the one person.
11.1 says all payments for the issuance of the bond shall be accepted in Indian rupees through demand draft or check or through electronic clearing system or direct debit to the buyer's account.
Yes. So it will have to be through banking channel. No, the purpose is this.
Bank, and therefore the issuing bank has all the data.
No. It would come, Lord. Therefore, it would come. The only person who would first know my name and is the person to whom I give KYC. Then KYC is sealed cover is maintained elsewhere. But it comes. Because within 15 days, many people purchases multiple bonds. But I may purchase 10 bonds worth 10 lakhs of rupees. So Guwahati, where purchases are made, or Trivandrum, where purchases are made, will send it in a sealed form to Bombay. So bond may have been purchased, my lord, from Chennai, but will be redeemed or can be redeemed in Calcutta. However, the political party can present the bond for redemption in any of the designated branches, which will credit the amount only in the main designated branch. They can go to Jaipur and say that this is my bond. The money would be transferred without anybody's name to the designated account wherever it is maintained, one designated account. So I'll have to ask several people to collude with me if I want to get the information. Because, Lord, I have not given that, but this center, Lord, Global Information Technology Center also, as I was, Lord, explained, I was also not explained in detail, and nor did I insist. But they also have 3-4 layers it goes, the request with the court order goes to one, he will open, then it goes at a second layer, then he opens, and everything is digitized, leaving the footprints. And therefore, my lord, to satisfy your lordship's conscience, I say that please criminalize if there is anybody who breaches this system. Lord, I'm not reading this, Puttuswamy, my lord, your lordships, all of my lords have read and read it. But the purpose, I'll say, Lord, your lordships have devised this concept of informational privacy. Lord, your lordships were examining two competing interests, namely, one, right to know, and second, right to have informational privacy. And your lordships have accepted information privacy to be a fundamental right. If, my lord, I am the person donating, and if your lordship's conscience is satisfied, that system is in public interest, your lordships can, Lord, accept my right to informational privacy as against general right to know. And why, my lord, I say this. If there is a genuine public interest in the disclosure, you go to the court, you have 7 for remedy. But merely for your curiosity, you cannot invade somebody's privacy if that privacy ultimately serves larger public interests. My lord, that's the submission which I have made, my lord. I have quoted the relevant paragraph. I am not, my lord, reading it. Your lordships are aware. Now, your lordships respected the privacy, but in public interest, if lordship says that if it is required, then of course with the order of the High Court. So it's not, my lord, as if it's an afterthought which I am suggesting to your lordships. It's already there in my written submissions, which shows, my lord, that the intention is not that there is no level playing field. Government, whichever is the party in power, knows about it, and the rest of them do not know. Nobody should know. That incentivizes clean money coming into the system. Because your lordships had a valid concern that in some cases it can be quid pro quo, in some cases it can be misused also. Nobody says that it cannot be. Any system can be misused. There can never be a system which is so foolproof which can never be misused. It can, my lord. In Indian ingenuity is, my lord, popular around the globe, and general human ingenuity, my lord, everywhere this is happening. There can never be a system. We have started, we have begun, and as I pointed out, the beginning is giving us fruits. Digitized money, my lord, is bringing clean money into the system. I have given the figures, my lord, of payment made by digital mode. Lord, the government, which consists of all politicians, the parliament consisting of all people in politics, my lord, they discussed this threadbare and found that there may be some lacunas in the system, but this is under the circumstances the best system. My lord, that trial and error, my lord, the government is entitled to. Lord, your lordships would always balance. I have argued this, my lord, I will not take your lordship's time further, but the legitimate state interest is linked to public interest. So you have the right to information, no denial, but you have the information which company purchased how many bonds, and you have the information in public domain which party got how many electoral bonds. If anything beyond that is encouraging cash, my lord, economy to enhance, my lord, that your lordships can balance, and that would be in the legitimate state's interest. That public interest would be of paramount consideration when your lordships examine this, my lord. When they say that you declare what is your property, you declare what are the criminal proceedings, these are all in public domain. At one's platform you declare, but here you are trying to lift the veil of confidentiality, which is by design made a part of the very system and which is the pivotal part of that system. And even the government doesn't know it. So, my lord, right to information cannot be claimed from me. As a large amount of money go to the ruling party, it is submitted that whether such an incumbent bias exists, and if it does, what its extent would be is a question wholly irrelevant to determining the constitutionality of the scheme. And, my lord, I have already said that that has been the trend. The ruling party gets maximum because ruling party has the confidence of the maximum people. Lord, I have said that secrecy per se is not alien concept in even electoral issues. Secrecy of ballot.
That's something separate. In your in the uneven level playing field, you've referred to fairness of elections. That issue is not been addressed.
Correct.
Has that issue with regard to fairness in elections been, or because of the mismatch between the money part, has that been addressed here? Because that may be larger picture, not specific, like alone to.
I'll just, my lord, again, my lord, try and attempt to point
No,
out.
you've argued that because of ruling party has always been getting substantially more donations.
My lord, average Indian voter, be it corporate or an illiterate voter, my lord, we have to accept this fact. And we should be proud of that fact. He is a very intelligent decision maker. A ruling party in 2013, though ruling party may not get maximum my lord, political contribution, because the voter knows that in 2014, the wind is somewhere else. We have to trust his discretion. So ruling party is not getting maximum because of the scheme. That's my submission. My lord,
According to even otherwise, the ruling party would get.
always. Lord, even before this scheme, I have shown from 2005 to 2014, whoever was ruling party, Lord, BJD is a ruling party in one state of Odisha. They have maximum, political contribution. That's the trend. That's how the people of India contribute. It's not as if because of the scheme the ruling party is getting any benefit and there is no level playing field. My lord, I have analyzed, my lord, in secret ballot, that secrecy per se is not antithetical to free and fair elections. Sometimes it enhances free and fair elections. Like, my lord, in my respectful submission, the present case. My lord, the argument that black money would be promoted is dealt with, my lord. My lord, please read, my lord, para 19, my lord. It's a long para. I don't propose, my lord, your lordship's time. But it's a similar argument that you are encouraging black economy. The court, my lord, analyzed the entire scheme and said that no, it brings the clean money into the system.